go live.
Right, but you'll have to pick not the one that has my picture, but the other one.
Yes, that's what I did.
It
Okay.
says now it's streaming on YouTube.
Okay. All right, we're good to go, Judge.
And then once you open that YouTube thing where it says it's going to stream, you need to close that browser because it will create a feedback loop because there will be a delay, and she'll hear herself talking in just a minute because there's like a 20-second delay.
Okay.
So as long as you look on the Zoom screen and it says that it is streaming,
Yes, sir.
then just close out the YouTube page that opened up.
Okay, we're good to go then.
All right, thank you.
All right, thanks.
Judge,
Okay, I'm going to admit everybody in for you, and I'll take myself out of the picture. And like I said, I'll be in my office if you need me.
okay, thank you so much.
Not a problem.
Good afternoon, gentlemen. Hi, Mr. Kessler. It looks like Mr. Gibbons is getting connected.
Okay. Hello, Judge. All right. Am I, okay. I'm not muted, am I?
No, you're not. Mr.
Okay.
Gibbons is muted.
Oh, okay, great, thank you.
All right, Mr. Gibbons, because I'm really not the host for this, you'll have to unmute yourself without me clicking on unmute. Thank you.
Sorry, Your Honor.
All right, let me call the case and then I'm going to ask you for appearances. This is cause number 16-00226, Daniel Stevenson versus Zabgo Enterprises. And then I want to talk about the status of Rudolph Chestang III, who is on the style as a party. And I'm Judge Kennedy. I'm a senior judge from the 114th District Court in Smith County, and I've been assigned by Judge Charles to preside over this matter. Would you all please put your appearances on the record, starting with any appearances for the plaintiff? You're muted, sir. You're muted.
Your Honor, I can start myself if you'd like. But Dan Gibbons on behalf of the plaintiff, Mr. Stevenson.
Is that Dan Gibbons?
Daniel Gibbons, yes, ma'am. Gibbins.
Thank you.
Your Honor, I think I'm unmuted now. So I'm Mark Elliston, and I'm a lawyer in Greg Price's firm, in addition to having my own law practice in Dallas.
And would you repeat your last name for me? I missed it.
Yes, Your Honor, it's Elliston, Elliston.
Thank you. And then, and you're also on behalf of the plaintiff?
Yes, correct. I'm a member of Greg Price's firm, in addition to having my own practice in Dallas.
All right. Anyone on behalf of the defense for Zabgo Enterprises?
Yeah, hi, Your Honor, Gary Kessler, Kessler Collins for the defendant, Zabgo.
And is anyone present for Mr. Chestang? All right, let's just go ahead and talk about Mr. Chestang. It's my understanding that there was a request for him to be a responsible third party, a motion to designate a responsible third party. Yeah, is that correct?
Your Honor,
Yes, we designated him as Rudolph Chestang III as a responsible third party.
Okay, so he really shouldn't be in the style. All right. I don't know if that motion was ever ruled on, but I'm going to look at the file. I really don't have the file. If you're not the court that was originally designated for the case, you don't have the file. But anyway, I'll review the motion to designate responsible third parties. If it hasn't been ruled on, I'll consider it. What I really want to do today is two things. I want to consider the request to retain this case on the docket after the notice of intent to dismiss. So I believe that should be either Mr. Gibbons or Mr. Elliston on behalf of the request to retain.
Judge, I'll be the one that presents the facts on that. Greg Price's firm is a pre-litigation personal injury law practice. He normally has about 300 cases, but he delegates or refers out those cases that need to be litigated. And he's been very successful over the years in that business manner. In this case, the incident in which our client was shot occurred in June of 2016. In August of 2016 or before, we referred the case out to Donovan Flowers for litigation. The petition was filed and the defendants were served in August of 2016. After that period of time, we started having problems getting updates from Mr. Flowers. We kept asking, when is a mediation going to be set? When is a trial set? As an example, in February of this year, one of our caseworkers sent Mr. Flowers an email stating we had been unable to get any updates from you since October of last year. I personally called many times unsuccessfully, trying to get an update from Mr. Flowers. In early March, I called and I spoke to one of his assistants who told me that the judge had not set the case for mediation or trial yet. Well, on March the 12th, Judge Martin set the case on the June 28th docket for dismissal for warrant of prosecution.
March 12th of what year, please?
March 12th of this year.
All right.
And then at that June 28th hearing, I related all of these facts to Judge Martin, and I requested just time to refer the case to another lawyer that we trusted to bring this case to a conclusion. At the conclusion of that hearing, Judge Martin advised he was taking the matter under advisement because he had a potential conflict. Turns out he had prosecuted and convicted the man that shot our client. We have now a lawyer, Mr. Gibbons, that has filed an appearance, and he has another lawyer that's very familiar with premises liability cases. They're willing to take this case to a conclusion. Our client is still greatly suffering from the injuries of this gunshot wound. He had to wear a colostomy bag for a long time, and it's very probable that he may have to again for the rest of his life. The delay in this case has not been the fault of Greg Price, and it's certainly not been the fault of our client. The statute has run, and our client would have irreparable harm if the court were to dismiss the case at this time. I respectfully request, Your Honor, to retain the case on the docket.
Would you go back to the communication you said you had, that there was a note in the file or some sort of communication about we haven't been able to get any confirmation from Mr. Flowers' office?
I have the email right in front of me, Judge. It says, this was from our Wendy Keith, who was an employee here at the time. Please send me an update on this case as soon as you have a chance. We haven't heard anything since October. At that time, your secretary indicated mediation nor trial had been set.
And what was the date? What was the date of that communication?
It was February the 8th, 2021. And I will just tell the court, advise the court that that is the same type of communications we were making frequently to Mr. Flowers, trying to get updates on what he's doing on the case. We had great difficulty doing it.
There appears to be one more participant in the hearing that wasn't there earlier. It's a gentleman whose photograph is just there with a dark suit, a white shirt, and a red tie. Does anybody know who that is?
I don't
see that. I don't see.
I don't
Judge
see it.
Martin. Sorry, it's Judge Martin. I was like, who is this lawyer that's in this case? I'm sorry.
Oh, okay.
I'm sorry about that. All right. Well, that's a long time to wait, counting on somebody else doing some work. All right, Mr. Kessler, on behalf of Zabgo.
Yes, Your Honor, thank you. Yeah, we don't think the case should be retained, Your Honor, just for that reason. We entered our appearance, and I'll tell you the exact date. We entered our appearance on behalf of Zabgo on September 16th, 2016. So we're approaching literally 5 years that this case has been pending. There's way more than enough time for Mr. Flowers to have gotten this case prosecuted. It puts our client at a great disadvantage. Witnesses come and go. 5 years ago, it's unlikely we're going to be able to have any of the witnesses that would have been available. I don't know where like you mentioned, we asked for the shooter to be named a responsible third party. I don't know if he's in prison, where he is, but the fact is, I mean, this case is a negligent security case. They're alleging that our client, which operated the Canton Travel Center, was negligent in failing to provide adequate security. So we don't think, Your Honor, that the case should be retained. And I guess, honestly, I mean, if they have a problem, if their client has a problem with this, then they need to take it up with Mr. Flowers. I mean, 5 years has just been way too long to have this sitting around. So that's our position, Your Honor.
Anything further from the plaintiff?
Yes, Your Honor. Our client has undergone hundreds of thousands of dollars in medical damages since this has occurred.
Mr. Elliston, you know what? That really doesn't have anything to do with good cause for failure to prosecute the case. And that's what I'm really interested in. What made your reliance on Mr. Flowers reasonable?
Well, we had sent him.
I don't even want to talk about the COVID year. I'm not even counting that year. But
I
really,
understand.
from the time the defendant filed his answer in September of 2016, let's just say 3 years, nothing happened. That would preclude you from proceeding under the standards. Even if it's a jury trial, that would be a 2-year. Why hasn't it proceeded in 2 years? You've got an extra year there. So why was it reasonable to keep thinking Mr. Flowers was going to do something?
Well, Your Honor, he's done stuff for us in the past, as my understanding. I've only been working with Greg's firm for 1.5 years, so I was not around when that was happening. But I can tell you that I am aware that he had handled cases in the past for us, and there had not been this kind of a problem. And we did have the pandemic, and that was one of the delays that they were saying was causing this, that the judge would not set the trial or mediation because of the pandemic. That went on for several months right there.
Well, and I understand that, but I'm not counting the pandemic years, the pandemic time. From September of 2016, let's just say 3 years, that would be September of 2019, before anybody in Van Zandt County or anywhere in Texas thought there was a pandemic there. I don't understand why it wasn't handled in that 3-year period. I'm taking out the pandemic year.
Well, there were depositions taken, because I've seen those as I reviewed the file, Judge, and there were some things that went on. The problem is we weren't being told what was going on. We were having a terrible time being told what was going on. So it's not like nothing happened. There were things that were going on.
Mr. Kessler, can you confirm that either written discovery or oral depositions occurred during that time period?
Yeah, there were 2 depositions taken, Your Honor. One was taken in December of 2016 by the plaintiff as to one of the owners of the company, and the second was taken in April of 2017, and there's nothing since then.
Was there ever any written discovery?
Robin, do you know that? I believe there was, Your Honor. We're checking right now.
All right.
We sent discovery, and they answered discovery. They did not send any written discovery. That I can see.
Your Honor, we're checking to see if
I see defendants. We sent out requests for production on September 16th. looks like we did respond to some discovery, Your Honor, in October of 16. Yes, we did. They had written discovery in October of 2016. We responded. October 19th, 2016, we supplied the written discovery responses.
All right. Based on the representations of really both counsel, the court is going to retain this case on the docket. The court finds there is good cause to retain the case. Like I said, I'm not counting the COVID year, and I'm not sure that you could have gotten the case to trial before, say, early 2020. So even though that's outside the 2 years deadline, I do find that there is good cause to retain the case on the docket. I'm setting this case for trial June 20th to 24th. That's an available trial week. That's in 2022. That's still a long way off. It's almost a whole year. It's a lot longer than I would give you if I had a lot of other trial dates to choose from. And I'm going to issue an order setting various pretrial deadlines and just a regular, really a scheduling order. Somebody mentioned a mediation. Was that you, Mr. Elliston?
Yes, Your Honor. We were requesting Mr. Flowers to tell us why hadn't the case been set for mediation.
All right. Mr. Kessler, is there any point in this case going to mediation from the defense standpoint?
Sure, Judge. I mean, we always agree to mediate cases.
All right, then I'll include mediation in the order. Could you all please confer and let me know if you can agree on a mediator?
Certainly, Your Honor.
Sure.
I like to do it like that because then you're satisfied with who you have and it's not me picking your mediator for you. But I need you to file it with the clerk electronically within 10 days, your designation of a mediator. And one of you can file it and represent that you've conferred and that is the agreed mediator. Any questions about that procedure?
No, Your Honor, I just want to be sure I got the trial date correct. It was June of 22, but what was the date on it?
The 20 to 24. That's, let me make sure that's, I got these dates from the coordinator who is very able. Let me make sure that I haven't messed it up though.
Your Honor, while you're looking that up, I mentioned to you that Mr. Gibbons will be the lead counsel for the litigation of this case now.
Right, and since Mr. Gibbons is on the call, as well as Mr. Kessler, who will be in some role with the defense, I guess you'll be trying it, Mr. Kessler, I don't know.
Yes, yeah, I'm planning on it. I'm
way.
just looking at my calendar, believe it or not. I have 2 cases set that week already. This is, I'm sure the court's aware that you know, it's been crazy with the resetting. Is there any chance we can go the next week instead?
No. Let me explain how this works. I'm sitting by assignment. Judge Martin already has a very full docket, and this is the date that I can set this case. This case has been pending since 2016, and it needs to be tried. Do you have any cases that are older than 2016?
No. No,
We
Judge.
don't, Your Honor, that I'm aware of.
No, I don't have any. Thank God. I don't have anything older than 2016.
Right. And how about Mr. Gibbons, are you still on the line?
Yes, Your Honor, I am, and I don't have an issue or a conflict with that trial date.
All right, Mr. Kessler, I need you to try to work out those dates because that is the date I have, and I don't have any intention of moving this farther along given the date that the case was filed and how long this has been pending. I'm sure your client is ready for some resolution on this matter as well.
Oh, yeah, absolutely. Yeah. All right. I'll
right.
see what I can do. Yeah.
Thank you. And where are the other cases set?
Pardon?
Where are the other cases set, Mr. Kessler?
Yes. One is set in the 160th here in Dallas, and the other is an arbitration in Iowa. So I have to work on getting that arbitration moved. Yeah.
Yeah, I know traditionally what we all do is wait for the trial date and see what's still left on the trial date. And, your cases may resolve in the few weeks right before the trial date. That's not going to work in this situation for two reasons. This case has been pending a long time and not through really any fault of the defense, but the case has been pending a long time. And also it's the date that we have.
Right. I get it. Yeah. Yeah, no problem, Judge. I'll make it work somehow. Yeah.
All right. If you would make in the report where you all designate an agreed mediator, if you would also indicate hopefully your success in getting those two things moved.
I'll do it. Thank you.
All right. Is there anything else from the plaintiff, either with Mr. Ellison or Mr. Gibbons?
I have nothing
No, Your
further, Your Honor.
Mr. Gibbons?
No, Your Honor, nothing further.
All right.
So, okay, I have a question, Judge. Who do I work with here, Mr. Gibbons or Mark?
You know what? That's sort of y'all's question, but I'll let one of them answer because it doesn't matter to me as long as something gets done.
Okay.
Well, Your Honor, we graduated from law school together.
Right. Mark and I are in the same class, so.
So that's an inside joke. All right. Well, I'll let you all figure that out on your phone. And in 10 days, please, a name of an agreed upon mediator and Mr. Kessler's progress in getting those two other matters moved off of June 20th.
You got it.
Yes, Your Honor.
All right. Thank you, gentlemen, very much.
Yeah, thanks, Judge. All right. Hey, Mark, give me a call.
Okay.
When we get off and we can talk.
All right.
Sure will.
Right, y'all need
Okay,
to talk
thanks.
and agree on a mediator, but I'm looking for the agreed mediator and the resolution of the other matters for Mr. Kessler, get them off of June 20th. In 10 days, if you'll file it with the clerk, then I'll issue the scheduling order.
Great.
Thank you,
Thank you,
Your Honor.
Judge.
All right, thank you, gentlemen. Nice to see you. Anything further from the plaintiff before in recess?
No, Your Honor.
From the defense?
No, Your Honor.
Thank you, gentlemen. Thanks for getting on Zoom here today. By the way, this was published to YouTube on the court's YouTube channel. Thank you all very much. We're in recess.
Thank you.
Thank you, Your
Nice
Honor.
to meet you, Daniel.